You know how sometimes trying to wrap your head around really complex legal battles, especially in tech, like patents, it feels like there's just so much jargon, right? So much information flying around.
Absolutely. It can be overwhelming.
Well, today we've got a case that really cuts through some of that noise. It gets right to the heart of how standard essential patents, SEPs, work in India, and it clarifies some pretty big questions.
That's right. We're diving into the Ericsson versus Intex judgment from the Delhi High Court. And this isn't just, any old decision. It's from a division bench.
Which gives it significant weight, yeah.
Exactly. Sets a strong precedent for other courts there.
And for this deep dive, we've gone straight to the judgment itself. We've got notes, key passages. We're looking directly at the court's reasoning.
Yep. So our mission today is basically to unpack this really important judgment for you. We'll pull out the key takeaways, the main arguments, and crucially, what this actually means for tech companies playing in the Indian market and, frankly, beyond.
Think of this as your guide to understanding a really pivotal piece of Indian patent law. So where do we start? Setting the scene.
Sounds good. Let's set the scene. Okay, players. You've got Ericsson, Telefonica LM Ericsson. Big patent holder. They were actually appealing in one part of this.
Okay.
And on the other side, Intex Technologies, India, Ltd. They make the devices, the phones, and they were appealing in the other part.
Got it. So standard patent infringement fight, but specifically about these SEPs in mobile tech.
Exactly. Standard essential patents. And the court, as I mentioned, is a division bench of the Delhi High Court Justices Manmohan and Saurabh Banerjee. And importantly, it was a unanimous decision. No dissent.
Right. And this wasn't the first time a judge looked at this, was it? It came up from an earlier ruling.
Correct. It was based on cross appeals. Both Ericsson and Intex were unhappy with different parts of a decision made earlier by a single judge.
Okay.
So they both appealed aspects of that. And this division bench decision we're talking about landed on March 29, 2023.
Okay. March 2023. Before we get into the weeds of their arguments, maybe we should just quickly cover the basics. SFs and FRAND. What's a standard in this tech context?
Sure. Good idea. So think about things like Wi-Fi, Bluetooth, 4G, 5G. These are technical standards. They're essentially agreed upon rules or blueprints.
To make things work together.
Exactly. Interoperability. Compatibility. So your phone, regardless of brand, can connect to a Wi-Fi network, or different devices can talk Bluetooth. That's the goal.
Makes sense. And a SEP, standard essential patent.
Right. And a SEP claims technology that is essential to actually implement one of those standards. The court even used the definition from ETSI, that's the European Telecommunications Standards Institute.
Yeah.
And their definition basically says it's impossible to make a standard-compliant product without using the technology covered by that patent. You have to use it.
Because it's baked right into the standards recipe, so to speak.
Precisely. And these standards, they're often developed in collaborative groups called standard setting organizations, or SSOs. ETSI is a big one. Companies come together there.
And that's where the FRAND commitment comes in, right?
Yes. Often, when a company contributes patented technology that becomes essential to a standard developed at an SSO, they make a commitment, a voluntary promise.
To license it on fair, reasonable, and non-discriminatory terms. FRAND.
Exactly. FRAND. It's a contractual commitment made to the SSO, essentially for the benefit of anyone who wants to implement the standard.
So it's a balance. The inventor gets paid because their tech is essential and widely used.
Right.
But they can't just lock everyone out or charge astronomical fees because people have to use their invention.
Precisely. FRAND is meant to tackle two potential problems. One is holdup. That's where the SEP owner, knowing implementers are locked into the standard, demands excessive royalties after the standard is set.
Okay.
And the other is holdout, where an implementer just delays or refuses to take a license, maybe hoping for a better deal later, or just using the tech for free while negotiations drag on, or while they litigate.
Dragging their feet.
Yeah. And the court here really emphasized this. FRAND isn't just an obligation on the patent holder. It creates mutual reciprocal obligations. Both sides have to negotiate in good faith.
It's a two-way street. So does Indian patent law actually mention SFPs by name?
Well, the main law, the Patents Act of 1970, doesn't explicitly use the term SEPI, but, and this is important, the court made it clear the concept is not alien to Indian law.
Okay.
It's been recognized by the Delhi High Court in previous cases, and significantly, it's now formally recognized in the Delhi High Court's own rules for patent suits, the 2022 version, so it's definitely part of the legal landscape now.
Got it. Okay. Foundation laid. Now let's get to the core conflict in Ericsson v. Intex, this big question about interim relief. Can an SEP owner actually stop someone from selling products or get paid before a full trial definitively settles patent validity, essentiality, infringement, all of that.
Right. This is where the judgment really shook things up in India because before this decision, there was a specific test that had been laid down by a single judge of the Delhi High Court in another case, Nokia v. Oppo.
Ah, okay. A previous standard.
Yeah, it was known as the fourfold test for granting interim relief in SEP disputes.
Fourfold test. What did that involve?
It meant the SEP holder had to show, on a prima facie basis, meaning like at first glance based on initial evidence.
Right. Prima facie, we'll hear that a lot. Based on first impression, not the final word.
Exactly. So the SEP holder had to show prima facie evidence for four things. One, the patent was essential to the standard. Two, the other party's product infringed the patent. Three, the royalty rate offered by the patent holder was FRAND. And four, the implementer was an unwilling licensee, meaning they weren't negotiating in good faith.
All four had to look likely at that early stage.
Yes, according to that Nokia v. Oppo test. Only if you cleared all four hurdles could the court typically order something like interim payments.
Okay. Now, how did the Ericsson v. Intex division bench react to that test?
They didn't just tweak it, they explicitly rejected it. They called that fourfold test contrary to law.
Wow. Just threw it out. Why such a strong rejection?
They had several reasons. First, they felt the Nokia v. Oppo test was based on an incorrect and limited reading of a really key international judgment from the UK Supreme Court, Unwired Planet v. Huawei.
So they thought it misunderstood a major precedent.
That seems to be the view, yes. They also argued it set an impossibly high bar.
How so?
Well, needing prima facie findings on all 4 points, especially things like whether a specific royalty rate is definitively FRAND at the interim stage, the court felt that was basically asking for a mini trial before you could get any preliminary relief.
Which kind of defeats the purpose of interim relief, right? That's supposed to be quicker.
Exactly. The division bench also pointed out that the Nokia v. Oppo test didn't seem to properly consider the Delhi High Court's own new patent rules from 2022.
Ah, the rules we mentioned earlier.
Yes. Those rules explicitly state that courts can order monetary payments instead of just issuing an injunction once there's a prima facie finding of infringement.
Yeah.
The fourfold test seemed inconsistent with that.
Okay. Any other problems with the old test?
Yeah, a big practical one. The court argued that such a difficult test gave implementers very little incentive to actually negotiate and take a license promptly. Why bother if the bar for the SEPI holder to get any interim relief is so high? It encouraged holdout, they suggested.
Letting them use the tech for free while the case drags on for potentially years?
Precisely.
Okay, so the fourfold test is out. What did the division bench put in its place? What's the new framework for deciding on interim relief in SEP cases?
They clarified the approach. The court needs to make a prima facie assessment focusing on 3 main things. First, is there infringement? Second, does the implementer appear to be an unwilling licensee? And third, is the royalty sought by the SEP holder prima facie FRAND?
So it simplifies it a bit. You still need to show infringement, unwillingness, and that your offer looks FRAND on the surface, but maybe not a definitive ruling on essentiality or the final FRAND rate at this early stage.
That seems to be the shift, yes, making it more focused on the conduct and the basic case at the interim phase. And crucially, the court strongly backed the idea that SEP owners can seek injunctions, both interim and final, against implementers who are found to be unwilling.
So stopping sales is still on the table for unwilling licensees.
Absolutely. They cited support for this from courts all over the EU's top court, CJEU, the UK Supreme Court, the US Federal Circuit, Dutch courts, German courts. And they reiterated that ordering monetary payments or requiring deposits at the interim stage is perfectly fine, supported by their own court rules.
Golby.
To prevent the implementer from getting an unfair free ride, basically, using the patented tech without paying while the full trial proceeds.
Okay, so a major takeaway. Getting interim money, or potentially even an injunction, is now significantly more achievable for SEP holders in India, assuming they can make that prima facie case on infringement, unwillingness, and show their offer isn't obviously not FRAND. Let's see how the court applied this to Ericsson and Intex. What were the findings on infringement, validity, and Intex's willingness?
Okay, infringement first. The court liked the indirect method of proving SP infringement.
What that involve?
Basically, you showed 2 things. 1, the patent claims read onto the technical standards specifications, and 2, the accused device, say, Intex's phone implements that standard. If both are true, infringement is inferred.
Because if the patent is essential to the standard and the phone uses the standard,
Then the phone must be using the patented technology.
exactly.
They even cited a U.S. Federal Circuit case, Fujitsu v. Netgear, that supports this logic. Comparing the patent to the standard is effectively comparing it to the standard-compliant product.
Makes sense. Less need to tear apart every single device.
Right. And related to that, the court also endorsed something sometimes called the silver bullet idea in SEP cases.
Silver bullet.
Yeah, the idea that proving prima facie infringement of just one representative patent from a large portfolio can be enough. Enough to potentially get an injunction covering the whole product that uses the standard, and enough to set a portfolio-wide royalty for interim payment purposes.
Wait, just one patent can be enough. Why not prove infringement for all the relevant ones?
Well, the court acknowledged the reality. Standards like 4G or 5G can potentially implicate thousands of SEPs. Trying to prove infringement and calculate royalties patent by patent at the interim stage or even at trial is just impractical. It's not how the industry licenses these things.
Right, they license the whole portfolio needed for the standard.
Exactly. The value is in enabling the standard. So proving infringement on a key representative patent can act as that silver bullet for the portfolio, at least prima facie.
Okay, that reflects the commercial reality. What about the validity of Ericsson's patents and whether they were truly essential?
The division bench upheld the single judge's earlier prima facie, finding that Ericsson's patents were valid and essential. But the key point they stressed here was about the onus, the burden of proof.
Who has to prove what?
The onus to prove a patent is invalid rests squarely on the party challenging it, in this case, Intex. The court was very clear, citing Indian precedent. Simply filing a request to revoke a patent doesn't automatically mean there's a credible challenge strong enough to deny interim relief to the patent owner.
So just saying, I challenge this, isn't enough. You need evidence.
You need to show something credible, even at the interim stage, yes. Intex had raised some specific challenges under the Indian Patents Act. For example, Section 13(4), which says a granted patent doesn't automatically get a presumption of validity.
Okay.
The court agreed, yeah, there's no automatic presumption. But that section doesn't suddenly flip the burden onto the patent holder to reprove validity at the interim stage. The challenger still has to make the case for invalidity.
Right. What about other challenges? I think there was one about disclosing foreign patent applications. Section 8?
Yes, Section 8. Intex argued for a very strict interpretation, basically. Any mistake in disclosing related foreign applications should kill the patent holder's chance for an interim injunction, like strict liability.
And the court.
Rejected that. They followed existing Delhi High Court precedent, like a case called Merck v. Glenmark. The court said that to refuse an interim injunction based on a Section 8 issue, the non-disclosure or error has to be patent and manifest, like really obvious and clear, and it has to be material to why the patent was granted in the first place. Intex, they found, hadn't shown that.
Okay. And the classic Section 3K challenge about software or mathematical methods not being patentable.
Again, the court sided with the single judge's prima facie view. They essentially reaffirmed the position that inventions involving software can be patented in India if they provide a technical contribution or effect. It's not just about abstract algorithms. If it has a real-world technical impact, it can be patentable, which aligns with international standards like the TRIPS agreement.
So it sounds like across the board on validity and essentiality, the court felt Intex hadn't brought strong enough evidence at this stage to overturn the initial prima facie view favoring Ericsson.
That's the gist. The court explicitly noted Intex hadn't provided much, if any, credible evidence or expert testimony to really back up its invalidity claims during the interim relief hearings.
Okay. Validity, essentiality, infringement, all leaning prima facie towards Ericsson. Now the big one, willingness. Did the court see Intex as a willing licensee?
No. The court found, prima facie, that Intex was an unwilling licensee.
What made them think that? What was the behavior?
It was mainly looking at their conduct during the negotiation period. The court pointed to Intex prolonging the licensing discussions for years. And then, significantly, while those negotiations were supposedly ongoing, Intex went and filed complaints against Ericsson with India's Competition Authority, the CCI, and also with the Intellectual Property Appellate Board, the IPA.
Filing official complaints against the party you're supposedly negotiating a license with. That does seem counterintuitive.
The court certainly viewed it as evidence of unwillingness to actually conclude a license deal in good faith. But here's the kicker, the really fascinating part. The court relied heavily on Intex's own statements, admissions they made in that complaint they filed with the Competition Commission.
What did Intex admit in their own complaint?
Get this. In their CCI complaint against Ericsson, Intex apparently stated that Ericsson's patents were industry standard, that they were essential to the ETSI standards, that India's own Department of Telecommunications recognized this, and this is crucial that Intex needed a license from Ericsson because, and this is a direct quote reference the court highlighted, there were no non-infringing alternatives available.
Wait. So Intex told the competition authority that Ericsson's patents were essential, standard, and unavoidable.
Yes.
But then in the patent court, they were arguing against validity or infringement or delaying taking the license they admitted they needed.
Exactly. The division bench found these admissions in the CCI filing directly contradicted Intex's stance in the patent litigation. It showed, in the court's view, that Intex knew full well they were using essential patents and needed a license, yet they were delaying and fighting it. This was powerful evidence of unwillingness.
Wow. That's a major lesson, isn't it? Be careful what you argue in different forums. It can come back to bite you.
Absolutely. The court made it clear they will look at the totality of conduct, including statements made elsewhere, so don't contradict yourself.
Okay, so Intex deemed unwilling. What about Ericsson's side? Was their license offer considered prima facie friend?
Yes, the court found that Ericsson's licensing offer and terms appeared to be prima facie friend.
What supported that finding?
They pointed to the fact that Ericsson had successfully licensed the same portfolio of patents covering the same technology to over 100 other companies globally. That track record of deals suggested the terms were generally acceptable in the market, plus the fact the Indian Department of Telecom itself had recognized the essential nature of the technology added some weight.
So the global licensing history was key evidence for the friend assessment at this stage.
It seemed to be yes, for the prima facie look.
Okay, so the court applies its clarified framework, finds prima facie infringement, validity, essentiality, Ericsson's FRAND compliance, and Intex's unwillingness strongly bolstered by Intex's own words. What was the final decision on the appeals themselves?
Right, so the division bench first reminded everyone of the standard for reviewing appeals against interim orders. It's based on a case called Wander v. Antox. Basically, the appellate court doesn't just substitute its own view. It only interferes if the single judge's decision was arbitrary, perverse, or totally unreasonable, a high bar.
Okay, and did they find the single judge's initial findings arbitrary?
No, they found the single judge's prima facie conclusions were not arbitrary or perverse.
So what did that mean for Intex's appeal where they were challenging those findings?
Intex's appeal was dismissed. The division bench upheld the single judge's prima facie view on all key points. Patents valid, essential, infringed. Ericsson's offer prima facie FRAND, Intex prima facie unwilling. They also upheld the use of the final product price as the royalty base, which Intex had contested.
Okay, so Intex lost their appeal. What about Ericsson's appeal? They were challenging the payment structure, right?
Yes, Ericsson's appeal was allowed. Remember, the single judge had ordered Intex to pay 50% of the interim royalty in cash and secure the other 50% with a bank guarantee.
Right.
Ericsson argued they should get the whole amount in cash up front, given the finding of unwillingness. The division bench agreed with Ericsson. They ordered Intex to pay the entire prima facie royalty amount in cash within 4 weeks.
So a clear win for Ericsson on that point. The interim orders from the single judge were effectively replaced by this stronger order for full cash payment.
Correct, though it's really important to repeat what the court itself stressed. All these findings, infringement, validity, willingness, FRAND, are prima facie. They are for the purpose of the interim order only. They shouldn't dictate or influence the final outcome of the full trial on the merits, where all the evidence will be examined much more deeply.
Understood. Still, this judgment feels like a pretty significant marker in the sand for SEPI litigation in India.
Oh, absolutely. It's a major development. It clarifies the path forward, especially for getting preliminary relief. Overturning that Nokia v. Oppo fourfold test is a big deal. It arguably lowers the initial barrier for SEPI holders facing implementers they see as holding out.
And it sends a strong message, doesn't it? That courts are willing to order payments, potentially substantial ones, early on if an implementer isn't seen as playing fair. And it validates the global portfolio licensing approach.
Definitely. The practicality of portfolio licensing got a clear nod. And as we discussed, the emphasis on the implementer's conduct, looking at negotiations, actions, and other forums, admissions, that's a really crucial practical point for companies involved in these disputes. Your behavior matters and consistency matters.
So bringing it back to you listening, is
Mhm.
especially if you operate in the tech space in India, maybe holding patents, maybe building devices using standards, why does this case matter?
Well, understanding how the Indian courts, particularly a key court like Delhi High, are balancing these complex issues, patent rights, standardization needs, competition rules, is just vital. This case gives a very clear window into the practical challenges of licensing these complex technologies globally and how Indian law is adapting, often taking cues from international practice, but setting its own course too.
It really shows the dynamics at play. So let's leave you with this final thought to chew on. This judgment puts a strong emphasis on stopping holdout and making sure implementers pay up for essential technology while still requiring SEP holders to offer FRAND terms. Thinking about the future of innovation and access to standard-compliant products in India, has the court landed on the right balance here? Does this decision ultimately help or hinder the goal of having both strong innovation and widely available affordable technology in the Indian market? Something to think about.